My name is Talitha Heaton. I am Group Partnerships Manager at MPA Group. Very happy to be joined this morning by Paul Loustalan from Reddie Grose, talking all about IP strategy and how to monetize your IP. So Paul, over to you. Would you mind introducing yourself, please?
Thanks, Talitha. Yeah, I'm Paul Loustalan. I'm a partner at Reddie Grose, a firm of patent and trademark attorneys. I have been in the IP profession for getting on for 20 years now. I've got a background in engineering, so work with lots of clients in the what we like to call the advanced engineering space, whether that's automotive or hospital beds or whatever it might be, wide-ranging technologies. Work a lot with startups, scale-ups, helping them put their IP strategy together and helping them implement it. And that's what we're going to be talking about today: how to build your IP strategy. And yeah, thanks Talitha for the invitation and for organising the event. We've got about 45 minutes. I'd like to make this as interactive as possible, so please do put questions in the chat. Talitha is primed to interrupt me with those questions and keep the conversation flowing. I think it's important that you get something out of this. So if you feel like I haven't said something, you've got a question, please do interrupt, as it were. But equally happy to chat afterwards. If you've got a specific question about your business, please do get in touch. I wonder whether we should start with the poll question, Talitha, first, just to get a feel for who's in the room.
Yes, so I'll run the first poll, which just asks which of the following describes you: business owner, employee, or business advisor. A quick note on questions as well. If you haven't used this software before, in the top right-hand corner, you can see a little kind of speech mark with a question mark in it. Speech box with a question mark in it. If you click on that, you can type your questions in there, and I will then obviously share them with Paul. So yeah, please do make good use of that. I'll just give you a few seconds. I think most people have answered. I will end and share results. So quite a good split actually between business owners and business advisors.
Yeah, great. That's it's interesting to know who's in the room, and I will try and ever so slightly tailor what I'm saying. But given the split, that might be a bit tricky. But I will do my best anyway. Yeah, today we're going to be talking about IP strategy, how to work out what that might look like, and then how to put it into effect. First off, though, what is IP for those who don't necessarily know what we're talking about in terms of what the scope of what IP means? A very brief overview. So we've basically got registered intellectual property rights, those being patents, which will protect effectively technical innovations, designs which protect the look and feel of your product. If you might be protecting the rounded corners of your Apple iPhone, and then trademark protection, which is protecting brands, so protect your company name or your product names, taglines, that sort of thing. So those are your registered rights, but intellectual property expands outside of that to include unregistered rights like copyright and things like database rights, confidential information as well, and then as a subset of that, trade secrets, which I will come on to in a bit more detail later on. But that's kind of the overview of what we're talking about in terms of intellectual property. And I wonder whether we can run in short order our next poll question, Talitha, just to get a feel for who in the room has used any of these registered rights and whether or not they feel like their IP is properly protected.
Yes, yeah. So you should see that poll come up on your screen now, talking about whether you have any patents, designs, or trademarks. Yeah, I can see the answers coming in, which is great. very quick. Great. So I'll just share those results. Quite a few trademarks.
Yeah, indeed. That's good to see. So there's a fair amount of experience in the room. So I will, again, I'll try and adapt slightly what I'm saying as to the more high level, deeper level, I guess, of what an IP strategy might look like.
Sorry, a question has come in
Okay.
from Peter. He's asked, he said he'd love to know how to IP protect a coaching exercise. Do I need to get it published in an article in a trade journal, or are there any other ways?
A coaching exercise, as in how to coach team members or coach clients, that sort of thing. Like, I guess that would probably fall under copyright, and so therefore, as soon as it's written down or spoken in public, it would automatically be protected by way of copyright. That is, copyright is not a monopoly right. Somebody could come up with what you're doing independently and not copy it, and you wouldn't be protected. But you're right. Perhaps publishing it in an article on your website saying copyright 2024 should give you that some protection and make it harder for somebody to argue that they have come up with it independently.
Thank you.
I hope that answers that question. Then
we do have. Sorry, I was going to say we do have one more poll about kind of confidence
in
IP protection. Shall I? Would that help to go with that now?
Yeah, please.
Okay. Because I think one of the things that we were talking about was what processes people have followed and when, and actually, is that enough, or does it fit kind of what the business is doing now?
Yeah.
I'll just give it a few more seconds. See, I think people are thinking about this question a bit more than the others.
Yeah. And I guess the answers are probably expected, because if you thought your IP was protected very well, then you might not be in this webinar. So yeah, thanks all. That's interesting. I've got someone's raising a hand. Is that a question or?
Yeah, unfortunately, I don't think we can, give people access to their microphones in this. So if that person can type the question, happy to pass that on to you.
Okay. So for now, I'll carry on. So with all that in mind, I'm going to take a slight step away from IP to sort of basically general commercial strategy, because your IP strategy should align with your general commercial business strategy and goals. Whether that's you seeking investment, whatever stage of that investment might look like, establishing your business in the market, and whether that be for manufacture of products to sell to businesses or direct sale to consumers, or if that establishment in the market is licensing on to other third parties for them to then use that IP you have generated in their own business. And then perhaps at a later stage, your strategy at that particular time might be to merge with another company or be acquired, or some other sort of exit, whether that's an IPO or a management buyout, whatever it might be. All of those factors, what you're trying to do within your business, should play into what your IP strategy looks like. So with that in mind, those commercial considerations are effectively, I think, one pillar of the three main pillars that you need to be thinking about when you're putting an IP strategy together. So commercial considerations, what are you looking to do in your business? legal considerations. What can you protect and how can you protect it, and what are the strengths of those different forms of protection, and then budgetary considerations, because depending on the stage of your business, you might have a great idea to have a portfolio of 50 patent applications, 100 trademarks, and 200 design registrations, but from a budgetary point of view, that's probably not realistic for a smaller company. So what do you do and when is a big question that you need to think about from the budget point of view. And a good way to start on pulling those three aspects together is to conduct some sort of IP audit. So determine what you have in your business by way of intellectual property, because once you've done that, you can then work out how you want to protect it if it's not already protected, and then what you might be doing in the future. So not all of these aspects I have here will be applicable to you, depending on the stage of your business. If you're a startup, you might just have some R&D that you need to think about, perhaps some competitor analysis, maybe some future product lines, perhaps less likely to have current products or an existing IP portfolio, although many in the room do seem to have some sort of existing IP portfolio. So in a bit more detail then, I'll go around clockwise. Maybe I won't go around clockwise. I'll start with R&D, I think, actually. So if you're an innovative business, you may well be conducting R&D to come up with your future innovations that you are going to put in the market by way of products or manufacturing processes or whatever it might be. That R&D will inevitably result in some sort of intellectual property. That could be a technical innovation that you could protect by way of patents. It could be that you're designing new products that would where the look of the product is important, which means that design protection might be the way forward. And so considering what that R&D looks like, the timescale of that R&D can feed into what your strategy should look like. You can effectively add in some gateways to your R&D process to determine at what point you need to be thinking about, okay, I know that stream of development will get to a stage where I might be able to seek patent protection in 6 months' time, put in a gateway in that project line to consider IP at that stage. And what you protect will come down to those other two pillars, effectively the budget, at what stage you're actually going to have the budget available to protect the IP, and then the legal considerations of what can actually be protected and how. And answering those questions, usually for smaller businesses, means on the budget side, you protect your core technology by way of patents, your core trademarks, your company name and key product names, and perhaps designs fall away a little bit, and you protect that later down the line once you've actually got a finished product that you want to protect the look of. And when you're protecting that core IP, that sort of sets out what your main part of your IP that you would be incredibly disappointed if your competitors were to copy, and will likely feed into the most aspects of your business. So by using that budget in a wise way, if you've got a piece of technology that sits in all of your potential future product lines, then protecting that is clearly key. And once you have that protection for effectively your crown jewels, and the business progresses and there's more budget available for protecting IP, you can then expand out, start filing, and excuse the mixed metaphor, start filing a sort of a minefield around that protection for the crown jewels to keep people away. And hopefully that minefield sort of slightly overlaps and it makes it difficult for others to get close to what you're doing, because that's what we're trying to do here. We are trying to make your business defensible, so that whatever stage you are at in those commercial considerations, so investors, acquirers, for example, will be looking to see how defensible your proposition is. How easy is it for others to come and do what you're doing? And if the answer is yes, it's easy, then the value of your business is inevitably going to be less than no, it's really hard. We can't get close to doing what these people are doing. We need to invest in them. We need to buy them, whatever that might be.
Cool. Sorry, there's a question about how to prevent competitors copying ahead of IP protection, or how you can, is there anything that you can do before that's in place?
So yeah, good question. There are, as I say, some of those IP rights just come into effect because you've done something. So copyright, effectively, as soon as you have drawn your product or come up with your design, then effectively copyright exists. No action needed. So that is one potential. But that only works if somebody is aware of what you're doing and they have copied it. Unfortunately, IP rights are quite unforgiving in this way. Other things like patents, if they got there first, then they got there first, and there's not much you can do about it. So it does come down to those unregistered rights. Now, there are caveats here. If you're developing something and somebody else comes out with a patent, but you have already put into process behind the scenes something that would infringe that patent, for example, but you started beforehand, then you as a business can continue to do that because you got there first, you just didn't do it publicly. But that means that keeping good notes, keeping good lab books, keeping a good journal of what you're doing and when you're doing it is important, because that can help. But on the timeline of stopping others copying what you're doing, getting some form of formal IP protection in place, it has to be at the core of that.
Thank you.
I hope that answers that question.
Yes, it does. I've had a question from Emma who's asked, can you protect a new app? And if so, does that come under patent?
Yes, you can protect a new app in multiple ways. So it's probably got some sort of app name, your company name, so you could protect that using trademarks. If it's got some sort of new looking user interface, you can protect that by way of design protection. So, and actually that could be a series of images sort of taking you through the story of the app, as it were, to the journey that the user might take through the app. So you could protect each of those screens by way of design protection. And then if the app is doing something technical, because that's the requirement for patents, if it's doing something technical, then you could protect aspects of it by way of patents. Because although people say software is not patentable, it's only the software code really that's not patentable, because that's protected by copyright. The underlying technical solution can be protected by way of patents. So if you are doing something new and interesting in the app, taking on interesting data, manipulating it in some new way, and then outputting something that affects the real world, because there needs to be some sort of real world effect, basically, then yeah, you could protect it by way of patents. It gets more difficult if it's effectively a business strategy that the app is putting into effect, but still potentially possible.
Thank you.
Maybe then I should go on to competitor analysis, because that is another important aspect of an IP audit, I think, is working out what others in your space are doing and what they're protecting, because not only is it important to make sure that you have a defensible proposition, you're protecting your own IP properly, but you need to make sure that in doing what you want to do, you don't infringe a third party's rights. Normally, that takes the form of perhaps a quick trademark search to make sure that your new product name or your company name isn't being used by somebody else and isn't being protected by them. From a design point of view, it's quite difficult to do design searches. Most people just sort of basically see what's on the market and then go away and see whether there's design protection for something that looks similar to what you're doing. From a patent point of view, a sort of freedom to operate search can be important. So if you've got technical innovations, then doing some level of freedom to operate search to determine whether there are patents out there that you might infringe if you go to market is an important step in any IP strategy. Now, earlier stage businesses probably leave that till later down the line, but you can do them relatively inexpensively. Most companies know their key competitors, key people working in their space, and so you could limit your searches purely to those companies, or you could go broader and search for the technology as a whole. And what that competitor analysis also tends to bring out is your key markets. So IP rights, I didn't say this at the beginning, but those registered IP rights are territorial. If you want protection in the UK, you have to file a patent or a trademark in the UK. If you want protection in the US, you have to file a separate application in the US. And so knowing your key markets, that leads to where you should be searching for those rights when you're doing some sort of competitor analysis. And then once you've done that, then you can limit your searches accordingly. And those key markets will also depend on your type of business and your strategy. If you're looking to have manufacturing bases around the world, then your key markets might be broader than if you were simply licensing out your products, your intellectual property to third parties. You can sort of put some of that risk onto them. And then,
sorry, I was just going to comment that this kind of plays into the point that you made earlier about kind of having your business plan and how that overlaps with IP and your IP strategy. And then I'd say it also plays into investor conversations, and looking for investment, whether that's grants or VC funding, knowing things like competition and who's out there and who's operating and who has what protected. Surely that must be quite an important part of it.
Exactly. It's all about providing people with assurance, effectively, of whether you have thought about the key things about your business, so that an investor can be comfortable investing in you, or an acquirer can be comfortable in acquiring you. And what having thought about IP generally means, frankly, is that you're probably a well-run business. It's just one of those extra checkboxes that the investors might think about. They may not even look any deeper. But if you say, oh, by the way, I've got an IP strategy, and 5% of your investment is going to go towards putting this aspect of it into effect, and then later down the line we might need some more cash to go broader, they're going to think, okay, these guys know what they're thinking, know what they're doing. I can have confidence in them, because people invest in people, and if it feels like the people know what they're doing, then people are much more likely to invest, right? It's those things go hand in hand. So although they might not delve deeply into your IP strategy, just having one is often enough. But obviously for your own business needs, then knowing what's in it is important.
Thank you. One other thing that I've heard investors talk about, which relates to IP, is when they're approached by businesses looking for investment, if they are asked to sign an NDA, sometimes they can find it irritating. Sitting on the other side of it, what advice would you give to businesses that are wanting to speak to investors, not really sure how to approach NDAs and IP and making sure things are kind of confidential and protected?
Yeah, it's a great question, and can be a tricky one, because it's a bit of a chicken and egg problem. Going back to one of those 3 pillars of the budgetary considerations, often you need a bit of budget to protect your IP, but often you don't have that budget until you get the investment. But how do you get the investment without disclosing your IP to the investors? Trademarks are kind of fine in this. You can disclose to whoever you like before you file a registration, but patents are quite unforgiving. So having that NDA in place it is important. If they're happy to sign, then great. If they're not, then having an initial conversation with the investors and saying, look, we want to get your investment. This is what we're doing, but we can't disclose any more detail here because we've yet to file patent applications, because we need the investment first. That's what we need some of this investment for, is to put our IP strategy into place, and part of that is filing patent applications. So having, and I would hope that most savvy investors will realise that, and will accept you just giving them a high level overview of what you're doing and what you're looking to achieve, without giving them the detail that would shoot yourself in the foot in terms of getting your own patent protection. And if they're not, maybe they're not the investor for you. And I know that can be difficult to hear, probably, because any investment is good investment, right? But you really want investors that sort of will happily shoot fast and loose with your IP. I don't know. And hopefully that initial conversation leads to, oh yeah, actually we are interested, happy to sign an NDA. But do still be wary about NDAs, because they are notoriously leaky, especially if you're talking to much bigger companies than yourself. And so setting out in the NDA the scope of what you're going to disclose and making sure that people have actually signed them is important, and not drifting into more detail. It can be, in those sorts of conversations, it can be really easy to get a bit too excited and say a bit too much. So try and bite your tongue.
Great, thank you.
I'm slightly conscious of time. So perhaps the sort of future product lines and current product lines are a bit more obvious if you've got and sort of feed in from what I was saying about R&D. If you know what your future products are going to look like, trying to capture some core IP that will fit in all of those products is great, particularly for things like Patent Box. Hopefully, if you've got products out on the market, you're getting some revenue and making some profit. And if you've got one patent that sits at the core of all of your products, then that one patent could be used for Patent Box for all of those products, and the worldwide profits for all of those products. So do think about that. And there are ways of filing simple patent applications purely to protect that core IP, purely for Patent Box purposes. You might not go any wider than the UK. All you need is a UK patent. So do think about those sorts of things. And then for those of you, and it did seem like a lot of you, who already have an existing IP portfolio, sort of have a note every year, probably, just to check to make sure it's still fit for purpose, that you're still using that IP, because costs can mount up when you're paying renewal fees. Most registered IP has some form of renewal fee that is annual. Just make sure you're still needing it before you pay those fees, I think is an interesting take home just to think about. It tends to come up later down the line when you've built up a big portfolio, you feel like you spent lots of cash on it, and you become reluctant to let things go, but do sort of step back and take note of what you really need going forwards, and think about cutting where needed. Another question that I get asked a lot, so once you've worked out what IP you've got and how you want to protect it, is when to protect. And if I can make my slides go to the next slide, there we go. Particularly with patents, this is an important question to answer because, as I say, they are unforgiving. Once you disclose your technology to the world, it's basically game over in most countries. So I like to equate technology readiness levels, which hopefully lots of people in the room are already aware of, the sort of TRL 1 to TRL 9, including the valley of death in the middle, which unfortunately probably nicely aligns with the point at which you should be thinking of patent protection. So if you're up early at TRL 1, TRL 2, you're probably a bit early for filing patent applications. And that's because a patent has to describe the technology in sufficient detail for somebody else to put it into effect. That's the deal you're making with the state. For 20 years patent monopoly, you're disclosing your innovation to the world to further humankind, effectively, and to put it in rather broad terms. Once you get to TRL 3, 4, 5, you're probably in a good place to start thinking and filing patent applications, because you've got to the stage where you've got a proof of concept of some variety, you validate it, it works, but it's probably not in the public yet. It's still sat in your own business. So filing patent applications then is great. Once you get to 6, 7, 8, where you start to demonstrate in a relevant environment, as it were, that relevant environment might be in the public, and so that would mean you would be too late. And then by the time you get to TRL 9, that almost certainly is too late, but maybe not in some circumstances. But yeah, do bear that in mind. So excuse the pun, but your patent readiness levels kind of equate to your technology readiness levels. So think around 3, 4, 5, and that's a good time. I think, what else did I want to say? So maybe I can go back just to have this in the background as I say more. So the outcome of this IP strategy, including whether or not you're ready to file your patent application, or your trademark application, or your design registration, whatever it might be, is probably going to be some sort of IP report, IP strategy put together by you, possibly in conjunction with patent attorneys, with advisors, setting out what you're going to protect and when, how you're going to protect it. And what that enables you to do is effectively see all of the pieces of the intellectual property puzzle that you have. So the overall picture is your business, and each piece is a different aspect, a different part of it, a different part of the technology, a different product, and each product might have multiple pieces within that puzzle, and working out how to protect each piece of that puzzle so that the whole is protected in an interesting and effective way, both commercially and from a budget point of view, is really important, and that should be part of your strategy. And often you can protect the various aspects of your business and your products perhaps by way of multiple IP rights. So you may have a key product, key technology that is protected by a few patents. So you've got your core patent for your crown jewels and a few minefield patents that sit around the edges. But you might think, oh, this key piece here, I can keep this confidential, and so I'm going to treat it as a trade secret, so that even if people get close to some aspects, they still can't quite do what you're doing because you've kept some of that know-how some of that information within your business as a trade secret. And that can be quite an effective way of cost effectively protecting yourself quite well. That sort of multi aspect way of protecting your IP. So I said I was going to come back to trade secrets, and probably now is the time. So trade secrets are a subset of confidential information. Most companies will probably have confidential information and quite possibly have some form of trade secret. But to keep it a trade secret, you need to treat it as such. So then you need to have controls within your business to specifically say this piece of confidential information is a trade secret. It's crucial to our business. So you would limit access to that information to only those who need it. So some sort of document control to make sure that Joe Bloggs, who is just building your product at the end of a product line, doesn't know the key aspect of that product. Keep it contained. And then you need to be careful of who you tell outside of your business, and that really does need to be under an NDA and as strong as you can make it, because otherwise, once a trade secret is out in the public, it's no longer confidential and therefore no longer a trade secret. So do bear that in mind. If you want to try to use trade secrets, you really do need to treat them as such and have process in place to make sure they don't get out of your business. Then other aspects to think about that will also fall out of IP audits are things like ownership. So if your R&D is being conducted in conjunction with a third party, a contractor, a consultant of some variety, which is often the case for smaller businesses, making sure that you own the resulting IP that is generated out of that piece of work is really important, and getting that locked down beforehand, before the work starts. Who is going to own the resulting IP? That's going to be me in this case. You can keep this aspect of it, and then actually assigning it afterwards, after the IP is generated, to make sure you've got that full chain of title effectively from whoever's actually developed the innovation to yourself, who's going to own it at the end of the day.
Paul, can I ask, how does that work between co-founders or directors where you've got multiple stakeholders within the business?
Yeah, if you've got an actual business set up, then your company agreement, the articles of association, I guess, of putting your business into effect, should say that what happens in that case, that is co-founder IP goes into the business rather than sitting with each of those individuals. But having something in writing about that, of who owns what, i.e. the business owns it, we don't own it as individuals, it is important, because people fall out. You might be best buddies now, but if in 5 years' time you come to that acquisition and suddenly there's a lot of money on the table, then unfortunately money can lead to divisions among co-founders. So making sure that you do own, the business owns the IP rather than individuals is important. Most of the time it happens automatically if those co-founders are also are directors or even employees as well. There's effectively an expectation, an automatic transfer from those people to the business. Certainly in the UK, not in all countries, but in the UK, IP tends to transfer automatically from employees or directors to the business, because there's a duty there to the business.
Thank you.
Then we have 5 minutes left, and I wonder whether we have any more questions. But I think there was a final poll. Is it worth doing that now before we run out of time?
Yeah. On that one. So this poll is about whether you have applied for or benefited from any of the kind of funding or things like Patent Box, which I know you mentioned earlier, or none of them?
Yeah, that should have been one of the answers, shouldn't it?
Yes, I know. I just realised if we're getting low response, that's probably why.
Yeah. Yeah, I wanted to run this poll now because it's interesting that nobody has used Patent Box. Do chat to MPA about that if you have some patents. And nobody's mentioned IP audit, because I wanted to come to, well, how might you fund this IP audit that you're advising, Paul? Well, the UK Patent Office has a grant fund available for this via people like Innovate UK, and there are funds available for you to do an IP audit at the beginning of your journey, and then once you've done that, and I think it's around £3,000 or so, you get to put an IP audit into effect. And once you've done that, there's actually then a further fund called the IP Access Fund to help you put that audit, that strategy, IP strategy, into effect. So I think that's £5,000 or so, or at least it used to be. Who knows what the new government will do with that? But yeah, so they're great things to know about. Patent Box is a great thing to know about, because if you've got one product protected by way of patents and it's making decent profits, it might pay for your whole IP strategy, frankly, putting it into effect. Yeah. What else? Any more questions? We are coming towards the end. I want to make sure people have had an opportunity to ask any questions, and if not, then I will perhaps go to my key takeaways from today. Got someone raising a hand. I think, unfortunately, you have to put it in the chat.
Yeah. Maybe,
while we're waiting for that question, I will go to my key takeaways while we've got a couple of minutes left. So, if you remember nothing else, hopefully these things will stick with you. Consider IP early. Develop that IP strategy, even if it's just, right, IP is not for us right now, we just don't have the budget in place. But when we get to this stage of our business, we will be thinking of it. Put that thinking in early, because you're less likely to accidentally give away your IP. You're less likely to infringe a third-party IP. There's nothing worse than launching your product with even just a new product name and a third party then saying, oh, actually, we've got a trademark for that in this space, so you're going to have to delay that launch or pull it off the market or whatever it might be. That's just embarrassing and costly. And by thinking about it early, you're more likely to achieve those commercial goals that you've got within your business. Which moves to point 2, which is align that IP strategy with your business strategy. That good IP strategy will enhance your overall business strategy. Shouldn't be considered as an afterthought, something that you only comes up once you start speaking with investors and they mention, what are you doing with IP? And don't just consider it a drain on resources, because IP is an asset. It can be bought, it can be sold, it can be licensed. You can use Patent Box to reduce your tax liabilities. You can use it to enforce, if you have to, against third parties, although most IP is sat there as a threat and not really as a hammer that you use to hit somebody over the head with. But nevertheless, that's there. You could enforce it against third parties, and that could result in some revenue. And then adapt as necessary. So in all of these things, just make sure IP is continually on something that you think about on a regular basis. Once or twice a year, how's our IP doing? Are we protecting it in the proper way to align with what we're trying to do with our business right now?
Thank you. Sorry, I'm conscious we've got 10 seconds left. So
yes.
We will send all of these materials, your contact details, kind of connect everyone in case, there's any other questions. Thank you so much.
Great. Thanks
Yeah.
all. Thanks, Talitha.
Thank you. Thank you. And yeah, I hope everyone's found this useful, and we'll be following up yeah, with links, grant information, and yeah, contact details for yourself. So thank you.
Yeah, I should have shown my final slide. I'm not doing the final marketing bit of please scan the QR code, and it takes you to my profile if you want to get in touch.
Perfect. Thank you very much.
Great. Thanks.
Thank you. Bye.
Have a good day all.